Hi, I'm Marc Stevens, author of Adventures in Legal Land, of course, Government Indicted also, which you can get both of them at markstevens.net. And I mentioned this on the No State Project on January 11th, because on January 10th I had done a hearing with, well, it was a phone call, it was not a hearing, with the Washington State Department of Revenue. And they were just as dishonest as any other tax agents, any other politician. That's what they do. But I want to do a little introduction here because I want people to be able to discuss this, because I believe it's almost an hour long. And people may say not much got accomplished, but when you go through that, I think what we accomplished was, one, a complete denial of cross-examination, basically. Was not allowed a jurisdictional challenge. The agent actually lied and said I could challenge jurisdiction. Then she goes and says it's off the table. It's just like what happened in New Hampshire with Bill. For some reason, the evidence proving that the Constitution actually applies to somebody is completely off the table, and what she said was it is beyond the scope of that hearing. So even though she agrees that the basis of their jurisdiction is the Constitution, the basis of their statutory authority is the Constitution, the evidence proving it actually applies at all, it's beyond the scope of the hearing. We also had a complete denial of a witness challenge. And what she does is she does something very sneaky. She's saying that I can make my jurisdictional challenges and I have to allow the witness to get on the stand. But what she doesn't understand, even though I pointed out, I think she was deliberately feigning ignorance, of course, that the Frank Fulton was not appearing as just a witness. He was there as the representative for the department. So as any other prosecutor who has the burden of proving jurisdiction, before you put a witness on the stand, you have to prove jurisdiction. You don't have to put a witness on the stand to do that. You just lay out the evidence, proving you have jurisdiction, then of course you can proceed. She was not going to have any of that. So I think it's very educational what you can expect from these people, and again, why it's so effective and so important to just stick to the evidence. You'll notice that a common thread throughout the entire phone call is that I keep hitting on there's no evidence from the accuser, Frank Fulton or Ryan Douglas, who I've mentioned on the show before. There's no actual evidence that the Constitution Code apply. He does a few things that are beyond stupid. He tries to claim that, and if you go to the 48-minute mark, he says that facts is not a definition of evidence, that facts are not evidence. And I had pointed out earlier, because he pulled a Bill Clinton, what this is mean. Well, he doesn't say that, but it's close. I said that evidence are facts that are relevant and tend to prove a certain proposition. And he disagrees with me. Well, of course they would disagree with me on what evidence is. This guy actually comes out and says, and you'll hear it on the video, and we'll also have available the full audio of this, so you don't have to watch just the video. He actually claims that a statute is a fact that the Constitution applies. So you just allow that. Don't think on that stupidity too much. But it's one of those. It's one of those mind-blowingly stupid things. The statute that I quoted is actually evidence the Constitution applies. And, of course, he couldn't explain that, and he refuses to explain that because you can't, it's just too stupid. I mean, I'm starting to get this more and more now, that the statute is evidence the Constitution applies, the Constitution is evidence the statute applies. I mean, it's circular garbage. It's just absolutely off-the-charts stupid. But, again, like I said, I'm going to have... in the article, we're going to have a breakdown of all the stupid things that was said in the time. So if you want to jump around and get to that, and we'll also have, again, we'll have the full audio, have a high quality and a low quality. But I want to urge everyone, if you've any questions or comments, any kind of discussion, not only call the No State Project. We're here live on LRN.FM every Saturday from 4 to 7 p.m. and 1 to 4 Eastern Pacific time. But I'm going to post this also on the forum at markstevens.net, and feel free to put your comments up there and questions or whatnot if you're not able to call the show. But if you have a question or comment, especially if you have evidence proving that somehow something that Frank and this hearing officer are not able to do, if you believe that there's evidence to prove that the Constitution and laws of the state of Washington or the government of Washington apply to people just because they're physically in Washington, called the No State Project, do what these two politicians, these two dishonest bureaucrats were unable to do. And all the other bureaucrats that I've ever spoken to and asked the question, you're more than welcome to call the No State Project, or, hey, post a reply video to this. But, again, enjoy the video. I hope it's very educational for you. Again, if you have any questions, markstevens.net. Post it on the forum or call the show. Hello?
Yes, is this Marc Stevens?
Speaking.
Okay, hi. This is Janine Purrington with the Department of Revenue.
I'm sorry, what was your name?
Put Janine Purrington.
Okay.
With the Department of Revenue for the hearing.
Yep. I thought I had gotten a confirmation with the number you had down here the other day, but okay, we're connected. Thanks for calling.
Yeah, I had a voice message that you wanted to make sure that we knew you were going to attend by phone, and I had a phone number to call you at. Did you try to call me at the 360 number?
I did, and when I called the other day, it was yesterday or Wednesday. They confirmed that I could. Well, whoever it was that I spoke to, it's not important. Said that I could just call that number, and it would put me through to the hearing room, but.
Okay. I don't think they realized that I was going to be working out of the Seattle office on Friday. So, okay. So I have you now. I'm going to put you on speakerphone.
Okay.
All right. And with me is Mr. Fulton.
Good morning, Frank.
Will you be the only one for the LLC attending today?
I'm sorry?
Will you be the only person for the LLC on behalf of the LLC attending today?
Yes.
Okay. And Mr. Fulton, we have a signed confidential. What's your position with the LLC?
I'm assisting today on behalf of Mr.
Okay, so you are a representative of the LLC, but not a member?
No.
Okay, and we have signed authorization?
Yes, ma'am.
Thank you.
Good morning, Mr. Stevens.
Yes, good morning.
Okay, so Mr. Stevens, do you know what the revocation process is about?
I do. I do have a number of objections, though.
Okay, well, I am not a judge. I'm not an attorney. If you have a concern about process or service, you will be given an opportunity to state for the record anything that you want to, including if you have concerns about the evidence that's presented from Mr. Fulton in his declaration. Just 1 second, please. Okay, sorry. In the time that you dialed in Olympia, they were trying to get a hold of me here, so there was a little confusion. But I told them I had you on the line already. So, all right. So getting back to the hearing process itself, we will go on the record. I will have a tape recorder running, and I will explain why. I will be asking you to swear an oath to tell the truth for the record. I am not an attorney. I'm not a judge. I am a hearing officer appointed with delegated authority by the director of the department. The statutory authority for revocation hearings and revocations of certificates of registration were in the notice of hearing and the notice of scheduled hearing that they were referenced in that document. Like you said, you had some objections, as I think what you labeled them. Any statements or questions or disputes you have with any of the information and records you can present for the hearing and in the hearing itself.
Okay. Well, I know you mentioned that you're not a judge, you're not an attorney. I mean, this is a hearing, correct? So objections are part of
This is a brief adjudicative proceeding under the Administrative Procedures Act in Chapter 3405 of the RCWs.
Objections are a regular part of the proceeding, though. I mean, I can make objections, and you'll hear the objections and make a decision on them.
Sure, I can hear those. Yes.
Oh, okay.
Objections is a legal term generally in a court proceeding. I certainly will hear any statements you have to make, but I do not make I do not listen to motions. I do not make judgments. I'm here only to listen to the record to make sure that the statutory requirements for revocation have been met. And of course, because this is an administrative proceeding under the Administrative Procedures Act, you have the ability to appeal further if you find that that you feel like some requirement has not been met, or you feel like there is some objection to the proceeding itself.
Sure. One of the objections that I have is I'd like to, and I've had quite a history. Well, not quite a history, but I've spoken with Mr. Fulton a number of times, and I've spoken with Ryan Douglas, his supervisor Mona Adams, and I may have spoken to a Vanderbrake, who is also one of the supervisors there, because one of the objections that I have, and hopefully we don't have to take this, it doesn't have to escalate. My objection is that Mr. Fulton has admitted several times to me as to not having any, and so has Ryan Douglas and Mona Adams, as to not having any actual evidence to prove jurisdiction over Mr. and his business. So my question to you would be, what evidence has Mr. Fulton presented to you that would lead you to believe that the constitutional laws of the state of Washington actually apply, and that there's any jurisdiction to even have a hearing?
Well, he'll actually testify to that. I did get a copy of his declaration and his exhibits like you did yesterday. I only just pulled them up and printed them this morning, but I haven't actually perused them yet. I'm waiting for his testimony to go through that. The conversation that we're having before I go on the record was just to make sure that you understood what this process was going to entail, so that we could get it, so that we could begin it and have on the record all of your questions and concerns recorded. So,
you're not recording yet?
No, I'm not.
Okay.
I started to say to you before we began, I wanted to make sure you understood what this process was. So if you understand, you said you had some motion questions and things like that, and I said that during the hearing we will have we'll have an opportunity for you to provide your statements or questions for the record, and we will record it and answer them as best we can.
Okay.
So, are you prepared then?
I'm prepared. We just still,
okay.
of course,
I'm
have a standing.
Going to go ahead and put the tape recorder on.
Yeah.
And the tape recorder is on. My name is Janine Purrington, and I'm a compliance project and policy manager with the Department of Revenue. I'm serving as the presiding officer for a hearing which is being conducted today, January 10, 2014, at 10:10 a.m. in the Seattle District Office. This hearing is being conducted as a brief adjudicative proceeding, and the purpose of the hearing is to determine whether the Department of Revenue should revoke the taxpayer's certificate of registration and if the statutory criteria to do so have been met. The parties are the taxpayer, LLC, which is registration number, and the Department of Revenue. At this time, I will ask the Department of Revenue's representative to please identify himself and state his title for the record.
Frank J. Fulton, Special Agent.
Thank you. Will the taxpayer's representative please identify himself for the record?
We're going to object to the characterization as taxpayer that I am here assisting in the LLC.
Okay, and you are a representative of the taxpayer then?
No, I'm objecting to the characterization of as taxpayer. That's been a problem from the start that Mr. Fulton nor any other representative or employee of the Department of Revenue has been able to provide one shred of evidence to actually prove that the Constitution laws apply and that they are in fact the taxpayer. It would be no different than me accusing Mr. Fulton of being a thief. I'd have to present evidence to show that he's forcibly taking property from somebody. I wouldn't just level the accusation without evidence to back it up. So to continually refer to them as taxpayer relieves Mr. Fulton of a burden of proof and already shows a bias that you may actually hold by referring to them as referring to him as a taxpayer. You've already made determination that the Constitution laws apply and that there's jurisdiction over him.
Is Electronic LLC holding itself out as doing business to customers in the state of Washington?
We would object to the characterization that's within the state of Washington, which is one of the issues that we've discussed before, which shouldn't even, well, until we establish that there's jurisdiction, and this could actually be a fair hearing, it's kind of premature to even get into that. The idea that his physical location means that the Constitution laws apply and he's a taxpayer, that argument has never been proven with any kind of evidence whatsoever.
Does Electronic LLC hold itself out as doing business to customers?
Yes, it does.
What physical address does it do that at?
I don't think that's even relevant unless there's evidence from Mr. Fulton to show that the Constitution and laws apply just because of a physical location in Washington. This is something we've gone through before. This is something that where Mr. Fulton, knowing full well, continued escalating this against Mr. knowing he had no evidence of jurisdiction. He brought this.
So you're unwilling to disclose that information to the department?
I don't think it's relevant. You already have a mailing
I do believe it's relevant. I've asked you that question.
I don't believe it's relevant until Mr. Fulton can produce any evidence the Constitution and Code actually apply just because of the physical location in Washington. So do you have any...
So are you unwilling to recognize the laws of the state of Washington?
I'm unwilling to recognize that Mr. Fulton or yourself have
any... Let
me finish. You're asking me a question. I want to answer it. I am not going to recognize that there is any evidence showing that the Constitution laws of the state of Washington apply to... because Mr. Fulton and Mr. Douglas have been completely unable to produce one shred of evidence to actually support that argument.
Okay. Well, I have heard you, and I'm going to continue. I understand that you object to the use of taxpayer, but it is a term under statute that applies to businesses that are doing business in Washington State. So at this point, I will continue, and you can certainly appeal on the grounds that I use that term under your objection.
Well, the term robber is also a term under statute, so I will refer to all the employees of the Department of Revenue as robbers because it is a statutory word, and I would imagine you would have no objection to that either.
I don't. You can certainly use that term if you so deem that you think it's appropriate. So.
Well, they are trying to take his property by force, so I think it is appropriate.
Well, we'll get to the testimony in a moment, please. Okay, at this time, I will ask the Department of Revenue's representative to please, I will hear comments from both parties, and I will consider any documents they wish to submit or any testimony they wish to provide for the record. This hearing is being tape recorded as required by Washington Administrative Code 458-20-10,001. This rule also requires that the testimony of witnesses be taken under oath. So at this time, will both of you please raise your right hand?
Well, I have an objection. I still want, now that we're recording, I want the jurisdiction issue to be addressed, that if Mr. Fulton has any evidence to prove the Constitution and laws of the state of Washington actually apply to Mr. Schultz, I think he needs to provide it now, or he can't meet his burden to prove jurisdiction to have a hearing in the first place.
I believe it would be appropriate for us to continue to swear, tell the truth before we answer those kinds of questions. So if you will hold on your comments for one more moment.
Well, it's not a comment.
Please raise your right hand and acknowledge it for the record that you have done so.
No, well, objection. We're going out of order here.
I told you I'm not a judge, and this is an administrative proceeding. Until the oath is administered, I don't feel confident that we want to answer questions and provide testimony either way until we have all sworn the oath to tell the truth.
Well, I have other objections. Not only do
Thank you, and you will have an opportunity to raise them.
But my objection is I don't believe that Mr. Fulton has any personal firsthand knowledge that the Constitution and laws apply and that he is qualified to testify against Mr. We have a history so far where he has admitted to me on more than one occasion.
You are testifying again before you have sworn an oath.
I'm not testifying.
And hold your questions, or what you call term motions, until we have completed that, and I give you an opportunity to express them for the record.
But my objection is he's not qualified to testify as a witness against Mr. Schultz.
Again, you are talking about objections, and this is not that kind of proceeding. It is an informal proceeding, and I'm asking you to adhere to the process that I have laid out, which is that I have statements to make for the record, we have oaths to swear, and then you will have an opportunity to provide any testimony, raise any questions or concerns you have at that time.
Well, one of my concerns doesn't involve Mr. Fulton; it involves yourself. So I'm concerned about how if my Mr. client can get a fair hearing here today. So one of the questions I have is he entitled to a fair hearing?
He is entitled to a hearing, but as I already said to you, that my purpose of the purpose of the hearing is to determine if the statutory criteria for revocation have been met. Until I can hear the testimony, I can't even respond to that.
Well, is he entitled to a fair hearing, though? Are you supposed to be fair today? You're supposed to treat him
So,
fairly.
so is the implication that it's unfair right now?
Well, I'm
Is
not
that what you're
asking you
implying?
that. I'm asking if he is entitled generally, if anyone who gets one of these hearings before you or someone else before the department is entitled to a fair hearing.
Yes, I was asked to administer this hearing because the regional managers who would normally have this hearing have been involved in the case and have more insight into more of the history, and therefore I could be impartial to this hearing.
So, if there was a
Is that
conflict of interest,
it's not a representative of a fair hearing?
well, it may be. Or if there was a conflict of interest, would it be possible? It does. I think we already know the answer to this. I just want to get it on the record. If there was a conflict of interest with a hearing officer, he would not be able to get a fair hearing.
I
Yeah.
guess that would be true if there was a conflict of interest.
Yeah, if we're just talking in general, I'm not accusing you of anything. My concern, though, is that are you holding yourself out as a fair, impartial, and independent decision maker today?
Yes.
Okay, let me just write. So, an issue that I have, and I know that this was not necessarily recorded. I'm trying to remember because I think
This is recorded.
No,
the tape is on right now, and
now.
yes.
No, I know it's on now, but there's a statement I want to bring you back to that was made prior, and I don't know if that particular statement was made. I believe you said that you were appointed by and acting on behalf of the director today.
That's correct. This is delegated authority to be a hearing officer.
Okay, can you please explain to me how you could be a fair, impartial, and independent decision maker when you're acting on behalf of the director?
I can be fair and impartial because I'm not aware of the details of this case, and I have no vested interest in the outcome either way.
Well, but you told me that you were, because Mr.
Do you
Fulton.
think that
Well,
the
let me finish.
directors-
Mr. Fulton is representing the department, but by what you said, you were appointed by and directed and acting on behalf of the same director. So, but then I asked you if you were fair, impartial, and independent today. You said you were, and I just need you to explain to me how you could be fair, impartial, and independent of the director when you're acting on behalf of the director today.
I see. So because we are all part of the Department of Revenue, we cannot be independent. We cannot have independent thought and review processes, is what you're implying?
I don't think I'm implying at all. I think that's what I'm saying.
Well, that's what the question implies to me. So.
Okay. Well, I just need, it seems to me a contradiction, and I go through this all the time.
Okay, well, and thank you for that opinion.
Well, I'm asking you to clarify how you could be independent of the director that you're acting on behalf of.
I am acting, the director delegated authority to me, and I am here as a hearing officer to hear the facts and circumstances of the case and determine in an impartial manner that the statutory criteria for revocation are being met and that this is going to be the best resolution. So this is the only resolution available.
Well,
so again,
well, what I see is that you want to rush the process. You want to skip the jurisdiction issue and swear Mr. Fulton in, and you're going to skip. Let me finish. I need to finish. You want to skip the jurisdiction issue. So. You want to skip the jurisdiction issue, and then I raise an issue of his qualification to testify, because even under Washington law, no witness may testify unless there's evidence showing that they have personal knowledge of the facts. And so I'm raising an objection to that, and instead of letting Mr. Fulton speak, who has not really said a word other than good morning, instead of leaving him to his burden of proof to show evidence of jurisdiction to have a hearing in the first place, to show evidence that he has personal knowledge of the matters he's going to testify to, you just want to go and ignore that. And considering the fact that you are acting on behalf of the director, I see that you're already demonstrating a bias in favor of the department.
Okay. Well, and certainly you can appeal on those grounds if you so see fit.
Well, that's very flippant of you.
No, it's not flippant. I just want to make sure that you understand that you do have appeal rights beyond this if you are unsatisfied with this process.
But I also understand that you said that is entitled to a fair hearing, and we're really off to a bad start if it's going to be a fair hearing. Skipping the jurisdiction issue is not
You have not given anyone in the department namely Mr. Fulton, who's here to testify, an opportunity to present the facts.
No, he doesn't need to testify.
You have argued that he's unable to.
Well,
you have not allowed. He's been respectful of what the process that is this hearing process, and understands that before he provides testimony, he needs to swear the oath, as do you. And so if we could proceed in an orderly fashion, we might get to the answer to some of the questions you have.
Well, that's what we're trying to do. Remember, he's not just here. Well, let me finish. Mr. Fulton is not just here as a witness. He is there as a representative of the department. He's acting in the capacity of a representative. And as a representative who brought this matter to a hearing, he bears the burden of proof as the representative, not the witness, but as the representative, to first provide sufficient evidence of jurisdiction before it can proceed to where testimony is being taken. You want to just turn things on its head and do things backwards and put the cart before the horse, and then accuse me of trying to to disrupt the proceedings, and that's not right.
You actually have created the catch-22. Before he can testify, he needs to swear and tell an oath, and you are demanding that he provide testimony before he's sworn that oath. So
you're misunderstanding. As a representative,
at this point, on the record, you will have plenty of things to dispute in an appeal. But at this point, I must ask that we return to the order in which I wanted to have this hearing occur, which is the oath. So I would like for you to raise your right hand and verify out by phone, by voice that you have done so.
Are you speaking to me?
Yes, I am.
I will not be taking an oath today. I'm not here as a witness. I'm here as a rep.
Okay, well, without swearing an oath, you won't be able to provide any testimony.
I'm not here to provide testimony.
You're not planning on providing any testimony?
No, Mr. Fulton doesn't have a shred of evidence to prove jurisdiction, so there's no real point in doing that. The man can't meet his burden of proof to even get in the door.
That's fine. I will. We'll have to make sure that as you begin speaking, then that you are only asking questions and not making testimony any further. So, as Mr. Fulton, would you please raise your right hand? Do you solemnly swear that the evidence you shall give in the matter now pending between Electric LLC and the Department of Revenue shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Fulton, would you please provide your testimony for the record?
Yes, my name is Frank J. Fulton. I'm a special agent with the Compliance Division of the Department of Revenue. Frank J. Fulton is an authorized CDM as part of my employment. LLC, the taxpayer, registered with the Department of Revenue on March 4, 2011, indicating a starting date for the business of January 2011, and tax registration endorsement number 35 was issued. A master business application record of filing is attached to Exhibit A, shows the following facts. Number one, the application was filed on March 4, 2011 at 10:36 a.m. Pacific Time with the State of Washington Department of Licensing, indicating a starting date for the business of January 2011. Number two, the application transaction was made online and paid for with a credit card, MasterCard. Number three, a trade name was requested by the applicant to do business as a with the business location of Fort Portman 318 Seattle, Washington. Number four, the applicant listed estimated gross income of $18 to $60,000. Number five, the applicant answered on the application when asked what products or services were being sold. Number six, the applicant answered retail in the section that asks what business activities in Washington State. Number seven, the application was prepared by checked yes on the application, indicating that he declared under penalty of perjury under the laws of the State of Washington that the information provided in the application was true, correct, and complete. Number eight, listed the business email address as last at gmail.com and a phone number of area code 45612. RCW 8204050 is titled Sale at Retail. Excuse me, I forgot to turn my phone off. So the law includes the term tattoo parlor services as a sale at retail. See Exhibit B. The taxpayer filed and paid tax returns for the periods of quarters 1, 2, 3, and 4 of 2001, as well as quarters 1, 2, and 3 of 2012. All of these returns were paid by electronic funds transfer, indicating retail sales tax was collected from the customers. See Exhibit C. Revenue agency in the Seattle office attempted to notify the taxpayer that quarter 4
Objection.
2011 quarter.
Objection.
You can hold your questions until he completes his testimony, please.
But it sounds like he's going to go on for about another 10, 15 minutes.
And is there a reason you can't hold your questions until then?
If he's making inflammatory statements, if he's taking things out of context, if he's being argumentative, if he's assuming facts not in evidence, yeah, of course. But if that's the way you want to, I could sit here and just make a list of all these, but
yes, that would be fine. Go ahead.
Okay, as I was saying, revenue agents in the Seattle office attempted to notify the taxpayer that the quarter 4 2012 and quarter 1 2013 tax returns were not filed and were past due. A past due letter was mailed to the taxpayer on May 16, 2013, and no response was received. On May 16, 2013 at 2:29 p.m., the Department of Revenue agent made a call to number 40, area code 48 made, but the line was busy and there was no option to leave a message. When the number is called, it immediately goes to a busy signal and there is no option to leave a message. An email was sent to gmail.com on May 22, 2013, and no response was received. The letter and email gave the taxpayer until May 28, 2013 to respond. On May 5, 2013, a summons was sent to the taxpayer requesting tax returns for quarter 4, 2012 and quarter 1 of 2013. On June 27, 2013, the department received the confidential tax information authorization form signed by authorizing the department to speak with Marc Stevens. See Exhibit D. I spoke with Mr. Stevens on August 20, 2013. By this point in time, the quarter 2 2013 return was also past due. Mr. Stevens asked me to provide the constitutional and jurisdictional authority of the Department of Revenue House to collect taxes against his client. I told Mr. Stevens I would issue a compliance assessment, here I have to refer to as a CAS, for the unfiled tax returns, which would provide the right to appeal, thereby providing him with a determination from the department which would have answers to his questions. The CAS was issued on August 20, 2013, Exhibit E. I checked with the Department of Revenue Appeals Division on August 8, 2013, and was told no appeal had been received. That's Exhibit F. Tax warrant 17620 issued on October 8, 2013, and filed in the King County Superior Court on October 22, 2013, under cause number 13-4-3A, because the taxpayer failed to file and pay the current tax returns for quarters 4 of 2012 and quarters of 1 and 2, 2013, see Exhibit G. Mr. Stevens called me on October 29th asking why I issued a tax warrant. I explained we spoken on it. So August 20th, 2013, I clearly told him I was going to issue a CAS which provided 30 days to appeal the CAS. If the CAS was not appealed or paid, the tax warrant was issued. The CAS was not paid or appealed, so I issued a tax warrant. I asked Mr. Stevens if a petition for appeal was made, and he said yes. He promised he would send me a copy of the appeal, but as of the date of this declaration, I have not received a copy of the appeal of the CAS issuance. On December 12, 2013, I personally mailed a notice of hearing to the taxpayer and taxpayer representative via first-class mail. See Exhibit H, Certificate of Service, and Exhibit I, Notice of Hearing. Tax warrant number 109A has been filed for more than 30 days and remains unpaid. The current balance as of this date is $5,677.71. In addition to the above noted tax warrant, the current balance, the taxpayer has not filed to pay the tax return for the period of quarter 3, 2013, which is past due. The taxpayer is not assigned to resell a permit with the Department of Revenue. Therefore, based on the facts listed in this declaration, the Compliance Division is hereby requesting that the Certificate of Registration for 602-999-435 be revoked. Signed in Seattle, Washington, January 10, 2014, Frank J. Fulton.
Thank you. I have two questions I wanted clarification on because you gave me a copy of your statement as well. In your statement about the taxpayer filed and paid returns for the periods of Q1, 2, 3, and 4 of 2000, you said 2001, but I think you meant 2011?
Yes, that's a correction. I meant to say 2011.
Thank you. And then also you talk about a letter and email the taxpayer given May 28th, 2013 to respond. You said May 5th, but did you mean June 5th?
I meant June 5th, 2013.
Thank you. All right.
Actually, the letter and email gave the taxpayer until May 28th. Is that where I'm supposed to?
No, you said the letter was dated May 5th, but you have June on your document, which is incorrect. I'm sorry, it's the one right below it. On June 5th, the summons was sent to the taxpayer. But you said May. Did you mean June?
I meant to say on June 5th, 2013, the summons was sent.
Thank you. All right, Mr. Stevens, you can go ahead and ask your question.
Frank, do you have a copy of your declaration that you had emailed to myself and Miss Purrington?
I'm sorry?
Do you have a copy of your declaration as a 40-page document that you a PDF that you had emailed to me and Miss Purrington? Do you have a copy? Do you have all 40 pages that you emailed to us?
Are all 40 copies?
Yeah, I'm having a hard time hearing what you're saying.
Okay, go ahead. He asked you if you have a copy of the packet of the 40 pages that you sent to Mr. Stevens and me for this hearing.
Yes, sir, I do.
Could you please go to the page number that you laid out any evidence whatsoever that the Constitution and laws of the state of Washington apply to and if there's any jurisdiction over him?
What do you mean by jurisdiction?
This is what we were getting at, Ms. Purrington. The man doesn't even understand what jurisdiction is, and how is he qualified to even testify that the agency has jurisdiction? I mean, I want you to point to the, let's take it a little slower then. I want you to point or give us the page number or the document that lays out the evidence you rely on to prove the Constitution and laws of the state of Washington apply to.
What's your definition of evidence?
The facts, sir. The facts. The facts that would go to prove a certain proposition. I'm not going to play the Bill Clinton crap, and if that's your intention to have me define words that anybody literate in the English language and has completed 6th grade English is going to ask, I'm not going to tolerate that, and I would ask you to stop that right now, because I won't participate in this hearing, and I'll make my objection and end it.
That's your prerogative, sir.
Well, Frank, don't pull this what is mean stuff. It's not appreciated. Now, please give us the page or in the document that where you lay out your facts proving the Constitution and laws of the state of Washington apply to.
That's my declaration.
Yeah, give us a particular, let's get specific here. Where in your declaration, what page and what document number, because you've got Exhibit A is 3 pages. Just get specific with us and tell us which exhibit and what part of your exhibit, of your declaration, lays out facts proving the Constitution and laws apply to.
Well, that's right on the notice of hearing that stipulated.
Where? Where is the evidence? So you're talking about in which document? What exhibit number is that? So I can turn to it.
Exhibit I, as in I.
Okay, I'm looking at Exhibit I. It's 2 pages long. Please show me and direct me to the paragraph, the page in the paragraph where you've laid out facts proving the Constitution and laws of the state apply to.
Well, it's page 1, and there's the legal citations there, authority for the hearing.
Well, objection, move to strike. I asked you for the facts that would show that the Constitution and laws apply, not show me a legal citation. We already have your legal citations, sir. I want the evidence, the facts that prove that the Constitution and laws apply to.
The statutory laws that apply are in Chapter 8232 RCW.
Yeah, I'm asking the witness where he lays out his evidence that the Constitution and statutes, the body of Washington state law, apply to Mr.
Well, and that's not the purpose of this hearing. As I stated at the beginning, this hearing is being conducted to determine if the taxpayer's certificate of registration should be revoked because the statutory criteria for revocation have been met.
Yeah.
And for the purpose of this hearing, as identified in the notice of rescheduled hearing that is the Exhibit I, lays out the statutory authority to have a revocation hearing.
And you told me before that, and this is why you pushed so hard to get this man on the stand and have him testify, that I was somehow disrupting. You said I could address and ask him questions on jurisdiction after he was sworn in. Now you're telling me it's outside the scope? Jurisdiction is not outside the scope, and if you're just going to stick to the statute, we need to determine whether it's being arbitrarily applied or not. And I want to know, his argument is the statutes do apply. I have that. He's on cross-examination. I want the evidence his argument is based on. So giving me a legal citation in response to a question for facts is not responsive, and I'm still waiting for an answer to the question. In fact, let's break this down even further, make it even easier for Mr. Fulton. Tell me where in your 40-page presentation, sir, you have evidence or facts proving the Washington Constitution applies to Mr.
How do you define evidence?
Facts, sir, facts. I think I've already, see, this is, again, I'm going to make an objection that the witness is being hostile. I've already defined for him what I mean by evidence. I shouldn't have to repeat myself every single time I ask the question.
So I heard evidence given about Mr. Registration of the business to meet the licensing and registration requirements of the state. The fact that he defined the business, that he identified the business activity, and that, and then Mr. Fulton defined that that's a retail transaction, and Exhibit B is the statutory authority for collection of sales and use of sales or use tax, or excuse me, the sales tax portion for retailing activities. So I've heard that. So
Well,
what other facts are you looking for?
Well, that he was required in the first place, and my cross-examination hasn't gotten to the point where we would discuss why somebody is doing that. Because Mr. Fulton will be able to tell me, just as the other agents have told me, you either comply or you go to jail. So it was done under threat, duress, and coercion. But we'll get to that. Let's get an answer to the question, what evidence do you have in your 40-page presentation that shows the Constitution of the state applies to Mr.
Again,
No, well, let the witness answer the question.
Statutory authority.
I'm not asking him that. The statute of authority comes from the Constitution, okay?
That's correct.
All right, so now I want to see the evidence that the Constitution has any application to my client.
Okay. And that is definitely beyond the scope of this hearing, and so if you have that kind of a dispute, I'm going to let you go ahead and proceed with the appeal process and ask that further.
Wait a minute. So we can't determine if so at this point in time, you can't make a determination one way or the other that the Constitution applies.
As you just said a moment ago, the statutory authority is authorized through the state's constitution. So, but our statutory authority is what we quote and rely on when we talk to people about their requirements for registration and reporting.
Right, but wouldn't you agree that unless there was evidence the Constitution was applicable, that you couldn't prove that the statute was applicable?
I believe that if the statute was in violation of the state constitution, it would have been challenged by now and have been overturned or corrected. I believe it's clear that
No.
the state statutes are authorized by the state constitution.
I'm not arguing that. What I'm saying is you have no evidence, and you're saying it's beyond the scope of the hearing to discuss whether there's evidence the Constitution has any application. If the Constitution has no application, neither do your silly little statutes. I mean, that's the way it works. See, we've now shown, by your own admission, the foundation of everything Mr. Fulton has done. The foundation, you're saying, is beyond the scope of this hearing. How do you determine that your statutes are applicable? I'm not saying constitutional. How do you determine that they're applicable and that there's evidence they apply when you can't determine or even discuss whether there's evidence your Constitution applies? That's putting the cart before the horse and completely irrational and illogical. Saying, we're going to determine that the statutes apply, but whether the Constitution does in the foundation, we're not going to hear that. I mean,
it sounds more like a testimony than a question, so I'm going to go ahead.
That wasn't testimony. Oh, come on.
You've had conversations since August of 2013 with representatives of the department. Had you had a dispute about that, you should have appealed the compliance assessment, the underlying compliance assessment when it was issued, and you'd had a chance to talk about that underlying tax application at that point. At this point in time, you have the LLC has gone beyond that point, and we are now at where we are talking about the unpaid tax liabilities. We cannot find no way to satisfy them, and therefore we don't want this business to continue to operate and build up more liability. You've presented nothing. Well, actually, you can't present anything because you refuse to take an oath to tell the truth. But
right.
Of your questions so far, I've not heard anything that overrides the proof of that the department has met the statutory criteria for revocation.
Of course you have. You said yourself, and the witness cannot point to any evidence the Constitution has any application. We could then move forward and say, what evidence do you have that the statute laws apply to to my client? And what evidence do you have that the statutes apply?
Okay, well, what I have heard so far, and basically the statutory requirements that there is a filed tax warrant that remains unpaid 30 days after having been filed, that there are no arrangements or any attempts to resolve this tax liability. Those are satisfactory. Those are the criteria that demonstrate that a revocation is appropriate in this case.
Well, no, that's not true. We have tried. No, ma'am, and that's not true. We have tried to resolve this, and every step of the way, we've gotten. And I'll talk to Frank more. Let me bring out some more of his testimony in a moment. I think we have brought out that, by your own admission, the foundation. Let me finish.
And provide testimony.
I'm not giving testimony, and you need to now. You're just being dishonest by saying I'm giving testimony. That's just wrong.
Well, I would like to hear the question.
Well, I'm trying to get to it, but you keep jumping all over my cross-examination.
Please make it a direct question. It's not a cross-examination, it's a question. This is not a court proceeding.
It is an administrative hearing. It's evidentiary in nature, and I'm cross-examining the witness. Why you would object or find an issue with that, I don't know. But I want to address what you're saying, because I don't believe that you're just not being you're not correct. You're saying I brought nothing out. I've completely well, let me finish.
Well, please ask the question.
I have completely ripped out the foundation of your jurisdiction. You're saying that the Constitution, the applicability of the Constitution is beyond the scope of the hearing. I've completely ripped out the foundation of jurisdiction, and you say you've heard nothing. Now, I know you said you're not a judge and you're not an attorney. I don't think you need to have an advanced university degree to understand that when the foundation of jurisdiction is ripped out and isn't even within the scope of the hearing, that's pretty significant. And the fact that you don't recognize that a lack of evidence proving jurisdiction is significant is more evidence of not only your bias, but that you're not being even remotely fair in these proceedings today.
So what was the question in all of that?
My question still goes back to my witness, and I'll have him clarify. So, Mr. Fulton, you don't have any evidence in this document or in your opening statement there, actual facts showing that the Constitution of the state of Washington apply to Mr.
I've already answered that question, sir.
No, you haven't.
I have.
I'm asking you to verify your testimony. I didn't ask the question before. I'm asking you just to verify your testimony. So you have no, I haven't asked the question before. You have no evidence in your 40-page document or facts showing that the Constitution of the state of Washington applied to Mr. anyway.
Well, I wasn't trying to be disrespectful when I asked you what you meant by evidence, and you answered facts, which is not the definition of evidence, by the way. But I gave you the facts in my declaration, and what I think I hear you saying is you don't accept those as facts.
You're telling me that RCW 82.32.215 is evidence that the Constitution applies to my client?
And it is also a fact.
You need to explain to me how RCW 82.32.215 is evidence that the Constitution applies to Mr. Schultz.
No, I do not need to prove that to you.
Yes, you do. You're wrong. You're a witness, and this is prior testimony, and I'm going to ask you questions on. And if you don't answer the question, I'm going to ask that all your testimony be stricken. That's kind of how it works. You don't get to come in and give what you believe is testimony, and then when you're asked a question to clarify that and explain it, to then turn around and say, I'm not going to answer it without some repercussions. So I'll ask you again. Please explain to me how RCW 82.32.215 is somehow a fact proving the Constitution of the state of Washington applies to.
There was like 4 questions there, so which one do you want me to answer?
I want you to give me the facts and demonstrate how RCW 82.32.215 proves the Constitution applies to.
So do you want me to demonstrate something to you or prove something to you?
Okay, stop. 82.32.215 is about the revocation, and it is the pertinent element for this hearing today. If you want to talk about statutory requirement for registration and reporting, or non-compliance to registration and reporting in different articles of that chapter in 8232 of the RCWs, those are different questions. The testimony that I heard presented today was about the statutory requirements for revocation. So you are going to a whole nother, you're basically trying to go back to the beginning of this case, prior, it sounds like, to the actual registration, and say, how is it valid that this LLC must register and report with the department? Is that the underlying question for you?
Well, it goes back to the beginning, and even if it wasn't my main objective with the question, the fact is he testified to that prior, and I can ask him a question on anything he's done, anything he's testified to today under oath.
But I haven't heard that. I mean, what I heard him testify to was that Mr. on behalf of the LLC registered the department, used the credit card, filed a couple of returns, said that the business does tattooing, which is a retail activity. I mean, where is this other testimony about the constitutionality of their requirement to register and report? Where did that come from?
It's not about the constitutionality. It's going back to all his testimony that the department has jurisdiction because of the Constitution, and as you agree, the Constitution is the basis of your jurisdiction. And I'm asking him for the facts to prove it actually applies to Mr. And all he's doing is giving me the cart before the horse. He's using the code as evidence or facts that the Constitution applies.
All right.
I mean, I'm just going based on what he's saying, and I agree it's ridiculous. I think this is some of the most ridiculous testimony I've ever heard, that the statute is somehow a fact and evidence proving that the Constitution applies.
To be honest with you, as the hearing officer, I'm not even certain I understand what question you're asking, and I've done this for years. I don't understand what you're trying to get to, and because you can't testify, you can only ask questions. I think that we are in a loop that's not going to get satisfied today.
Well, I think you've already stated. You've already stated that the jurisdiction.
Hold on. I'm sorry to say that you are going to have to appeal, I believe, if you have further questions, because I don't believe that this hearing process is going to satisfy your questions and concerns in any way. Because you won't swear to tell the truth, you cannot testify, you can only ask questions. You're asking questions that are not pertinent to the matter at hand. So at this point, I'm going to conclude this hearing. I do find that the Department of Revenue has proven their case and that the statutory requirements for revocation have been met. It is hereby ordered that certificate of registration number...
Well, objection. I told you I still had other questions to ask the witness. No, I'm not going to. I think what you're doing is rude, and I think that this was, I told you I had more questions to ask my witness, and you're cutting off a cross-examination.
Again, another issue you can raise an appeal. I do not find that your cross-examination is in any way pertinent to the revocation and the underlying criteria for revocation.
I have a whole list of questions here. I had to write them down as he was giving his testimony.
Number 602-999-435, issued to LLC, shall be revoked. This is an initial order. It will probably come out in writing today or Monday, and you will have 10 days from the date on the notice to timely appeal or to resolve the underlying liability. If that's not done, then the final order will be issued.
So you made a determination, even though you said jurisdiction was beyond the scope of the hearing. You still made a determination it was jurisdiction and it was proper to go after my client.
I did not say that. Okay. This hearing is concluded.
This is all.
The hearing, the tape is going off? Okay. You can appeal, sir.
So why don't you just answer the question, ma'am? How can you make a determination against my client when you've already stated that jurisdiction is beyond the scope of the hearing?
I say questions about taxability, which is I think what you mean by jurisdiction, are beyond the scope of the hearing.
No, you said when it came to the jurisdiction...
The taxpayer does not even have an obligation with the state. This taxpayer self-registered and has a reporting obligation. You already said at the beginning that they do hold themselves out as doing business.
Yeah, but you're assuming that just because he's physically located in Washington that the Constitution laws apply. And you, by your own admission, said that evidence proving that the Constitution laws apply is beyond the scope of the hearing. You just assume that they do, and you assume there's jurisdiction, just like the other robbers. And I notice that you keep calling my client a taxpayer, but you don't refer to Mr. Fulton as a robber. So a nice little double standard there. And that's what you guys are doing. You ignore the issue of jurisdiction and then dishonestly make a determination that there is jurisdiction.
Thank you very much. I appreciate all of your feedback, but I can tell that it's clear that we are not going to be able to resolve this together.
No, you're totally unfair, and you're acting on behalf of the director, which we brought out. Your goal was, and you said you were acting on behalf of the director, and all you're doing is rubber stamping what the director has said. And to say that jurisdiction is beyond the scope of the hearing, I imagine it's going to be funny to see how your lawyers try to twist and turn that one, since the whole thing has been recorded. And I think what you're doing is dishonest and it's immoral. If jurisdiction was beyond the scope of the hearing, you have no business making a determination at all. That's the way logic works.
I thank you again for your opinion about me and how I act, even though it was unsolicited. But certainly I will respect that you have the right to your opinion. So. Thank you very much, and good luck with your appeal. Goodbye.
Very flippant again, ma'am.